Okay, so our next concept is the division of powers, and I feel like this concept helps to explain all of the roles of the lower and upper house and the crown as well. Now, first of all, being able to define it. So, lawmaking powers are the powers given to parliament to create certain types of laws. So, we have the division of powers enshrined in the constitution so that we are able to decide which parliament gets what powers. Imagine if there was confusion about this. Imagine if both Commonwealth and state level parliaments could make any laws as they please in any area. What we would have then is we would have inconsistency between those laws, and it would be unclear to understand which is, superior. Do I abide by the laws regarding this concept present in my state, or is it the laws of at Commonwealth level, at Australian level that I have to follow? So this would cause a lot of issues in the courts as well, because the courts, if there's conflicting laws present, how could they possibly decide during a dispute who is in the right or who is in the wrong? And if a person has or has not broken a law, if they are different. Okay? So this is why we must have the division of powers to delegate all the areas in which both the states and the Commonwealth can legislate in. So these include exclusive, concurrent, and residual powers. So we need to be able to provide a definition for each and give examples. Okay, so now exclusive powers are the lawmaking powers that are held only by the Commonwealth Parliament. So in these areas, only the Commonwealth can legislate and the states cannot legislate in these areas. So the examples are really easy to understand and come up with. If you have a look at these examples, they're clearly things that the states shouldn't be able to decide. So these include things like defense, military, the currency within Australia, border protection, import and export outside and into Australia with other countries, um, and signing, treaties and things and declarations with other countries, things like that. Okay, so these really are only the areas that relate to things like international trade and currency and domestic issues. So most powers and areas in which we legislate in are actually residual. They're not exclusive. Residual are the powers that belong to the states and the matters on which the states can legislate in. There are actually, what I'm saying is, there are actually not that many exclusive powers, just because the whole nature of the concept, the Commonwealth level law applies to areas that refer to international trade relations, um, and so there's not that many. Okay, so we said exclusive powers are held by the Commonwealth, and we're able to define that and provide a few examples. Now, concurrent powers, it's literally in the name concurrent, so clashing or shared. Okay, so these are the lawmaking powers that are held by both the states and Commonwealth parliaments. And you might be thinking, well, how does that work? How can we have, um, wouldn't we have those overlapping laws or different laws if that is the case? And this is where Section 109 of the Constitution is coming into play, which explains exactly what will happen if both a state parliament and a Commonwealth parliament make law in the same area and the laws contradict. So we'll look at that in a second. First of all, what are some examples of concurrent powers? So things like trade, taxation, and laws around marriage and divorce. So, for instance, with the taxation example, if we have a think about this, how's that concurrent? So if we look at Commonwealth Parliament level, that would include the tax you get on your income and your tax return. That is a Commonwealth level law that applies to everyone. Everyone gets taxed the same all over the country, no matter which state they live in. Okay. However, if you look at state level taxation laws, there are many examples here too. So, for instance, when someone owns a house or land, they have to pay tax or money to their local council. Okay, so there are state level and Commonwealth level laws regarding taxation. So that helps to give you an example of some concurrent powers. So let's see section 109. Remember, this is really accessible, so you need to be able to explain this in quite a bit of detail. Section 109 explains what occurs if under concurrent powers, a state law and a Commonwealth law contradict each other. So the actual section of the Constitution explains exactly what's going to happen. When a law of a state is inconsistent with a law of the Commonwealth, so they are clashing, the latter shall prevail, and the former shall, to the extent of the inconsistency, be invalid. So this is saying that when a law of a state is inconsistent with the law of the Commonwealth law will continue to operate. Because the Commonwealth law, it makes perfect sense, it should be superior over a state level law. And the state law is abolished or it's gone, but only to the extent of the inconsistency. So only the part of the state law that contradicts with the Commonwealth law will be abolished. And the rest of it will operate as usual. We only care about there being no contradictions. If there is a contradiction, the Commonwealth is superior and their law will prevail. So, very important when you're answering these questions and what will get you and where you will lose marks is if you forget that state legislation only becomes invalid to the extent of the inconsistency. So, the part that is contradicting only. Okay? So, that's very, very important. You're welcome to, for the sake of your responses, actually memorize the section and what it says. I definitely used to just have it memorized because it's quite an easy section. But you're absolutely free to explain it in your own words. Just don't miss to the extent of the inconsistency. Very important. So you can really see that section 109 is yet another law or section of the Constitution that helps to expand Commonwealth law and Commonwealth's lawmaking powers at the cost of the state's powers. Which, when we look at the High Court cases that you need to know, we said you must know one High Court case in relation to both state and Commonwealth Parliament. You'll see that this is always really the case. Like all the High Court decisions tend to result in an expansion of Commonwealth law and a reduction in state lawmaking powers. Okay, so we looked at exclusive powers, which belong exclusively to the Commonwealth, concurrent powers, which are powers that are held both by state and Commonwealth parliaments, and now we have residual powers left. And I mentioned that these are the majority of lawmaking areas are actually residual. So most lawmaking power is held by state parliament. Not by Commonwealth, by state parliament. Okay, so residual powers. Again, it's really easy to remember because residual means everything that's left over. So these are lawmaking powers held only by the state parliament, and essentially it is any area that is not mentioned in the Commonwealth Constitution. By default, that becomes a state parliament power. So anything that's not mentioned in the Constitution and given to Commonwealth Parliament automatically is a residual power and is a state power. So this turns out to be the majority of lawmaking powers, exactly what I said. Most lawmaking powers are residual and belong to the states. And why that is the case, because when the Constitution was initially established and written, the purpose was not to take away power from the states, but allow them to retain it. So obviously, Australia coming under one country, all of the states and areas had concerns that they will lose all of their freedom and there will be a single parliament and everything will change. So the Constitution aimed to bring them together and leave them most of their powers and allow them to retain it to help encourage them to establish a single country and a single Commonwealth Parliament. Um, and that was the whole purpose of that constitution. So what are some examples of residual powers? So things like public transport, the public transport system, such as the train system, is different in every single state. Um, criminal law as well. There are different laws in each state with regards to crimes and the criminal justice system and penalties and sanctions, different fine amounts for different offenses, as well as different sanctions for each serious offense, as well as education. So every state also has a different education system. So the ATAR, all students get an ATAR across the country, but all the systems are different under which you study and the layout of subjects depending on the state that you are in.